Please, Your Ladyship, I represent the applicants, to be with my learned friend Mr. Shapiro. Thank you.
Please, Your Lady, I represent what we call the vision respondents, together with my learned friend Mr. Tongaat.
Please, Your Ladyship, I'm here with Mr. Ramsey for IDC.
Fine.
Please, Your Lady, here for the Cane Growers Association from
Mr. Van Rooyen, yes, thank you.
Please, my lady, I am here for the Minister of Trade, Industry and Competition.
Yes.
Lady, I appear for Abrina intervening party, Jodaf D.
Thank you, Mrs. Jodaf.
Lady, I appear for the intervening shareholders for Berkeley.
Yes, Mr. Wadsworth.
May it please you, my lady, I on behalf of IGS,
Yes. Thank you, Mr. Coxon. Mr. Civil, what is the position?
Thank you, my lady. Lady, as we've indicated to you earlier, there's been a very recent development in the matter, and that is that an agreement has been reached principally between the IDC and Vision, to which the BRPs are also a party, and we have filed a short affidavit updating Your Ladyship on the current status.
Yes.
The effect of it is that the BRPs we represent are satisfied that the need for the relief that we originally sought, in other words, terminating the business rescue and placing the company under winding up, that relief is no longer necessary. In fact, on the basis of the arrangement that's been reached, the BRPs are satisfied, and we submit that the court, we would seek that the court endorse that there's a reasonable prospect of rescue. It's on that basis that we would seek the leave of the court to withdraw the application. As far as costs are concerned, we submit with respect there should be no order for costs. It's not a straightforward classic commercial matter where there's a successful or unsuccessful party. Until yesterday evening, as far as the BRPs are concerned, the relief that was sought, the winding up, was still warranted and necessary. What's changed is the circumstance of an agreement now that the RDC and Vision have been able to reach, which will release funding to the BRPs to continue in operation. As we indicated on the last occasion, certainly the BRPs don't want to see this company failing. A rescue would have been.
Yes, that has been
it's always been
the approach in your heads of argument that were lost.
Correct. And unfortunately it wasn't to be unless there was money. So it's a very simple matter. They can't continue operating unless there was a particular PCF, which is now made available under this agreement. So it's not a question that any party who may be seeking costs today has been successful. It's changed circumstances. We're not quite sure who. I think Abrina is going to be asking for costs. We're not sure if there's anybody else who's seeking costs. But if they are seeking costs, we submit with respect. It's an entirely inappropriate order that they're seeking. They've not been successful. They would have to persuade Your Ladyship that on the circumstances that existed at the time that this application was instituted, that it was ill-founded and that the BRPs have been unsuccessful. There's no question of not being successful. It's a question of this company now being assisted further by virtue of the latest agreement concluded yesterday evening. It's not something within the control of the BRPs, as you're aware. The BRPs are certainly reliant upon the PCF flowing from the RDC, and that's only become available. And what it's achieved is perhaps a further lifeline, as we were before Your Ladyship earlier in this year, in April, where we urged that the court adjourn the matter to afford the parties a further opportunity. We find ourselves in a similar position, but we can't keep the winding up application pending, and because that also has consequences
Yes,
as concursus, and that's why we submit with respect the appropriate orders on the basis of what we now have, and we're not sure that there's anybody opposing that, is a withdrawal of the application. But as far as the costs are concerned, we submit that the correct order would be no order for costs. If a party such as Abrina wants cost, effectively what they're doing is they're asking the company, which they say they're very anxious to save, to pay the costs. But we submit with respect, it's not a matter where they have been successful. In fact, there's no success on their part unless the court were to have found that there was no merit in the application to terminate the business rescue and to wind up.
So in other words, if this court granted a provisional order of winding up?
If it grants a provisional winding up, then the BRPs would have been successful. If the court had refused that on the merits,
Yes.
then Abrina or others may have an argument that they were successful.
Yes.
But they're also seeking, as we understand it, to avoid the winding up. They've been contending that there's other finance and other plans that must be explored. What exactly that is, we submit is the proverbial pie in the sky. But when it comes to costs for the withdrawal of this application, they would need to satisfy your ladyship that they would have been successful in opposing the termination of the business rescue and the winding up on the merits. And with respect, we submit with respect that that's nowhere near the case. Unless and until this agreement that was concluded yesterday evening, unless that was in play, with respect, there was no option but to wind up.
Yes.
Thank you.
Thank you, Mr. Sobel. Mr. Fine, maybe I should ask you what your position is.
We support the application and we agree with our learned friend. There should be no order as to costs.
Yes, thank you. Mr. Blow?
Thank you, Lady. The division, as you know, the division parties are party to the new basis for carrying on with the business rescue. We had never opposed the application formally anyway,
Yes.
but we are not objecting to the withdrawal of the application, and we are not seeking costs as against the BRPs.
Yes, thank you. Mr. Van Rooyen?
Capenga has taken a similar position and opposed the application. So that we not seek costs.
Yes. Mr. Cholke? Yes.
Milady will recall that the opposition of this application was intended to preserve business rescue or ask the court to exercise its discretion not to grant the winding up.
Yes. That has always been the minister's stance.
That's always been the stance.
Yes.
And consistent with that, milady, is that the IDC was similarly mandated by the minister as shareholder representative to support the business rescue. And milady, in that regard, there's no objection. In fact, we support the withdrawal of the application, and consistent with our approach in supporting the sustainability and the possible success of the business rescue is to seek no audit as to costs.
Yes, thank you. Mrs. Deodath, what is your position?
My position that Mayor will be arguing for the costs. I'm not certain Milady wishes to hear from a land of
Yes, perhaps I should, and then I should hear.
Let's go, please.
Yes, Mr. Allsworth?
Maybe we should close the application, to withdraw the application and leave costs in the hands of the court.
Yes, thank you, Mr. Allsworth. Mr. Kotzer.
May it please you, my lady. Lady, RGS's position remains that it is not able to argue the counter application today, given the agreement that was provided just before court started.
Have you had opportunity to peruse the affidavit?
I've had an opportunity to peruse the affidavit quickly. The crunchy part of it is not actually what's in the affidavit, it's the terms of the binding heads of agreement that have been concluded last night.
Yes.
So that's where the exercise lies in comparing that to the adopted plan and to the representations made at the creditor level. I'm not in a position to address this court on the impact that this has on the counter application. And I don't intend to argue the point now, because as I understand it from my learned friends, Mr. Subel and Mr. Blau, we are basically in agreement that the matter can stand down to be heard tomorrow morning. And
In respect of the counter
in
application.
respect of the counter application only.
So what is your stance regarding the withdrawal of the main application and the issue of costs? Because that is what I am asking.
We welcome the withdrawal because that's part of the relief we sought in the counter application. And as far as cost is concerned, our position is simply that only as far as RGS is concerned, its cost position must only be assessed once the counter application has been determined. If there's substantial success in that regard, it may or may not affect the position regarding costs. But if RGS does get the relief it seeks in the counter application, it may well be entitled to costs, at least insofar as the opposition to the counter application was concerned. So the short submission is that that is best assessed after argument is heard on the counter application.
And in relation to the main application, Mr. Kotze, because that is what I'm asking you about. Your counter application, as I understand, is that business rescue was to continue, which is what is going to happen, and for the liquidation to be refused, and now the application is being withdrawn. So my question to you is, in light of the main application, what is RGS's stance on costs?
Yes.
I understand you on the counter application.
Yes.
That this court cannot determine
Yes. Well,
right now.
I do think it is best dealt with in the argument for the counter application because it is really the same thing, milady, because the first prayer in the counter application was for the liquidation application to be dismissed. So there are arguments to say that the BRP were premature in launching that application, but really it all bleeds into one, and it's all best assessed once the outcome of the counter application has been determined, because the dismissal of the liquidation was the first prayer in the counter application. So the simple submission would be that the assessment of those costs be made together with the outcome of
So
the
reserved for the counter application.
which would be reserved to tomorrow morning.
Well, whilst we're on that point of what is to happen to the counter application, there's an affidavit filed. Are you going to be standing and arguing from the bar tomorrow? Assuming your instructions are to pursue the relief.
Yes, I think the position is not that we need to file a further affidavit. The facts that require argument are only the facts that the BRPs have put up in the affidavit filed this morning, and then there'll be argument on the agreement that the IDC, the BRPs and Vision have concluded. So there's no need to file further affidavits. It's simply a question of taking this afternoon to consider the documents that were provided this morning, to take instructions, and then to have a little bit of time, which is only reasonable, to present informed argument to this court tomorrow morning. And as I say, I understand that there isn't really opposition from my learned friends, that there isn't opposition to the counter application being heard tomorrow morning. So perhaps I won't argue the merits of having it heard tomorrow morning unless opposition to that does arise.
Yes.
Excuse me.
Are those your submissions?
Those are my submissions.
Yes. Thank you, Mr. Kotze.
He's happy to argue on the papers, that's fine.
Yes.
We're happy to hear what he has to say. But if it's matters of law that, I mean, have not been traversed in his or whatever at all, we're going to have to just see what he says. I mean, it's...
Well, you may have to assess that tomorrow then.
That's what I'm saying.
Yes,
if he says it's something we want to put in written submissions, I'm not sure they can stop us, because it would be new matter either way. But we're happy, we would like to get rid of the application one way or another if we can.
Yes.
But we're not waiving rights. If he comes up with further arguments that we say should have been canvassed properly in a different way, we're just reserving our rights in that regard. Thank you.
Thank you.
Lady, may I just say something, please? You observed that IDC had not originally entered the fray with Vision, but one of the conditions of this new agreement that has been concluded with Vision is that it falls away if the BRP plan is set aside. So I'm taking instructions from IDC as to whether they would want us to be present tomorrow and argue. If so, I will make shorthands available to your ladyship, if that is in order, and I'll advise my learned friend. He can reserve his rights as to whether we have got a right to argue or not. But it might be that I don't get instructions. I'm just alerting your ladyship. and we will try and accommodate the court and make it. It won't be a long argument, but about just placing our position on record in that. And my learned friend has indicated to me that we hadn't entered the fray. That is correct, but we say there's a new dimension here, and we might or might have to argue it.
Yes. Well, the matter is set down for 2 days, so.
Yes, thank you, Milady.
Yes, Mrs. Deodath, what is the position with Abrina?
Well, Milady, like all the other parties, we're quite happy for the liquidation application to be withdrawn.
Yes.
Because Milady, we've seen from our papers that our stance has been that it ought not to have been brought in the first instance. So we're quite happy that they've withdrawn it. The position is that we are seeking the costs. This is a situation of where, and I'm not seeking costs on a punitive scale, Milady.
Yes.
We're seeking costs, but for counsel's fee to be on scale C, because it's a fairly complicated matter that required a fair amount of research and preparation. It wasn't an ordinary matter, Milady. But that's for Milady to obviously decide the scale of costs. Now, Milady, the position is an application was brought in circumstances where, apart from Abrina, several other parties in this matter would have indicated this matter wasn't properly brought.
And they're happy to have no orders to cost. So,
well,
what is so special about Abrina, Mrs. Deodath?
Well, Milady, just to the extent, if Milady looks around the room, the rest of the parties in these matters are large organizations generally. Abrina is a small grower, Milady, and at some extent, on the previous occasion, one of my learned friends would have raised to the court, we've got no skin in the game effectively. But with respect, it is the cane growers, or the growers themselves, who is the lifeblood of Tongaat Hullett. We have entered this fray to stop a situation where the BRPs were trying to put Tongaat Hullett into liquidation. We came up to represent the interests as a small grower, Milady. We've incurred the costs by coming to court. Now, Milady, on the previous occasion, we had indicated when there was this attempt then to try and, when they had concluded, I think it's addendum 11, between IDC and Vision, and on that basis the matter was adjourned to allow them to do, to try and work out a plan between them in terms of Vision and IDC. Milady, our position was we opposed that application for the adjournment, not on the basis, Milady, and it was misunderstood by the public in general, not on the basis that we sought for Tongaat Hullett to be put into liquidation, because we contended at that stage, the moment that they decided to go into other arenas, it was clear that the BRPs did not believe at that stage that Tongaat Hullett could not be rescued. It was at that stage in the previous occasion, Milady, when they ought to have withdrawn the application at that stage. Instead, what they've allowed us
or
to
pursue the application.
Well, Milady,
and rather risk of having a provisional order being granted.
Well, Milady,
on an unfunded liquidation.
Well, Milady, with respect, as far as this matter is concerned, and it's been our contention, I'm in a position to argue the matter, Milady, if Milady requires it. The position is we contend that the application wasn't properly brought. We contend that there was a reasonable prospect of Tongaat Hullett being rescued. We've contend there's no compliance in terms of the Act, Milady. We also contend that insufficient information has been placed before Milady for Milady to arrive at the conclusion that Tongaat Hullett cannot be rescued, Milady. Milady, so based on that application was, as far as we are concerned, they were not going to succeed. And taking into account all of the opposition of my learned friends, obviously my learned friends who represent larger organizations, the cost can be absorbed easily by them. But Milady, this matter has required several affidavits, Milady will see. The matter has been on the opposed roll on 2 occasions.
Mrs. Deodath, Mr. Civil made the submission that effectively what Abrina is seeking is asking the very company that it wants to be saved to pay the costs. So what is your submission on that?
Well, Milady, to the extent that, and Milady, in this regard, I'm going to refer Milady to the affidavit that was handed up by my learned friend this morning. A copy of the agreement, I'm going to refer Milady to page 11 of that heads of agreement, paragraph 4.7.
Withdrawal of liquidation application.
Yes, Milady. The last paragraph, the last sentence of that paragraph, Milady will see that to the extent that a court orders costs arising from the withdrawal to be paid by the BRPs shall be entitled to discharge such costs from the IDC PCF facility. Now, Milady, provision has been made with respect for the possibility that a court may find that they are liable for costs.
Please, will people sitting stop muttering whilst counsel is addressing me? Yes, sorry.
Yes. Milady, ordinarily, when a party withdraws an application that is before court that is fully opposed, they would have to tender the costs. That is the normal rule. There's no reason why the BRPs in this scenario should be excused from it. We've contended that they haven't acted properly. Unfortunately, the reality is we're not seeking costs against the BRPs personally, Milady. We're seeking against the company, but it will come out of the PCF. But it is a situation where the application was not properly brought before Milady. in terms of what the Act requires. They haven't even put Mlady in possession of any financial facts relating to Tongaat Hullett. Effectively, simply a situation of they wanted Mlady to put it into liquidation on the simply say so of the BRP, simply because they said so. Mlady would have to accept that. Mlady is not a single financial document, management account, annual financial statement, anything put up. And my recollection, Mlady, years ago was, when it comes to liquidation application, the best way to demonstrate that a company is insolvent or not insolvent, put up the financials. Now, this company has been in business rescue for many years. It never happened. Now, Mlady, and Mlady will see that the first party that entered this fray was Abrina. Before any of the larger entities that are in court, it was Abrina that brought the application believed to intervene Mlady. And they stepped in to try and assist Tongaat Hullett at this stage. But the problem is, Mlady, who's going to bear these costs? Now, in as much as I accept, Mlady, that it was a vision and IDC that arrived at this agreement, the reality, Mlady, is it is the applicants that have brought the application, and they sought to withdraw the application. They could have limited costs and withdrawn on the previous occasion, which is what we suggested, Mlady, but they elected to adjourn the matter. Substantial flurry of affidavits was exchanged between the parties. Mlady, in that circumstance, it's unnecessary costs.
Yes.
Lady, so to that extent, it's our contention, Lady, that at the very least, the applicants ought to be directed to pay Abrina's costs, Lady, with counsel's fee to be on scale C. I'm not asking for punitive costs, Lady, but obviously the scale of counsel's fees can be determined by Lady. But with respect, there's nothing before Lady to show why they should not be directed to pay the costs. What the BRPs are trying to do is to appeal to the sympathy of the court to say, well, you're asking the entity who we are trying to rescue to pay. But the reality, Lady, that entity is represented by 3 professionals who are the business rescue practitioners. They have exercised their discretion in bringing this application in circumstances when we asked them not to bring it. They have brought all of us to court, and particularly they brought us to court, a small grower. So to that extent, Lady, we contend that we are entitled, at least for where we are concerned, we are seeking the cost. We're a small grower, we've had to absorb the cost in coming to court to try and save Tongaat Hullett, Lady. They've seen the light eventually, Lady, so to that extent, I would submit that we would be entitled to the cost, Lady.
Yes, thank you. Thank you, Mrs. Judah. Mr. Sobo, anything in reply?
Thank you, if I may. Firstly, if I may start with Abrina, it's a rather remarkable argument we've heard. It's as if as I understand the argument, the applicants, the BRPs, ought to have withdrawn this application before because it was an ill-founded and, as I understand, incorrect or improperly brought application. What we ought not to forget here, it's common cause between all the parties that it's a distressed company within the meaning of the Act. It's common cause that it doesn't have funding other than in the event of the IDC providing the funding. And it's common cause with respect that the company is factually and commercially insolvent. So for our learned friend to argue to your ladyship that there's sympathy being sought, it's certainly...
He says it's not common cause because the BRPs did not put up sufficient financials.
What I've said to your ladyship is it's common cause that it's a financially distressed company. The financial position has been set out many times. Of course, they've given the financial information. It's been made available to all the affected persons, and there's no debate on these papers that the company is commercially and factually insolvent. The debate, as your ladyship will be aware, from RGS and from Abrina, has been that this isn't the only plan available, and that what ought to happen is that they say that the plan must be set aside. We know what the counter application says, and what they're saying is that the BRPs must now go in search of another plan, must try and find another funder, must now try and find a different plan, put together a plan, put it again before creditors. It didn't answer the fundamental problem, and that is who's going to pay for this operation next week? Who's going to pay tomorrow? And unless there's money to continue the operation, there was no prospect of saving the company. Now, as your ladyship is aware, the application that's currently before you that we seek to withdraw is brought in terms of 141.2. There's no discretion there. There's a statutory obligation on the part of the BRPs, who are officers of this court, that if they conclude that there's no reasonable prospect for the company to be rescued. Now, at the point in time this application was instituted, That's what they say they concluded. Nobody has gainsaid that. Nobody has said, neither Brina nor RGS or anybody else for that matter, no, you do have money and you can continue. Once we know that there's no reasonable prospect for the company to be rescued within a time frame that will save the company, the BRPs are obliged under 141.2 to apply to court, which they did, discontinuing the business rescue proceedings and placing the company in liquidation. There's no ifs and buts about that. There's no discretion. It was obligatory, and that's the application that is before you. And what Abrina is now arguing is that there was an ill-conceived application. They have not shown your ladyship that there is funding currently today available, that if we had not got further PCF in April, that the company would have continued in operation. People need to be paid, supply needs to be paid, the cane growers need to be accommodated. I just want to say something about the cane growers, lest an impression be created that's not correct. Abrina is but one cane grower. They do not represent, our little friend does not represent the cane growers. She's representing one of them. As I understand, they are an applicant for intervention. I'm not even sure, I've been trying to find out. I don't see a record of them even having been granted leave to intervene.
No, it was one of the issues.
Absolutely. So currently their locus is also a big question mark. They're making the most noise. They're not an affected person. They're one of the cane growers. And with respect, whether they have a voice at all is doubtful. So we submit with respect that, as far as the Abrina is concerned, just to deal with certain of the arguments advanced, our learned friend refers your ladyship to clause 4.7 at page 11 of the agreement that's annexed to the affidavit today. That doesn't assist the argument. That means that the IDC will allow the payment of costs that are required to be paid out of the PCF. That's money that should be available to be used in the business rescue to assist in the payment of liabilities, including employees and so forth. So that's not an additional fund. So clause 4.7 doesn't, with respect, advance the argument at all. She then says it's a normal position when you withdraw an application to tender the costs. Well, we must understand what this application is. What are these circumstances? This is a sui generis Company Act obligatory application brought by the BRPs, who were obliged, without any, with respect, firstly, locus standi of Abrina to be even arguing, but secondly, without any indication that there is currently funding outside of the PCF that the IDC last night has agreed to make available. So unless until that happened, with respect, we're still in the same position as we were in April. And the supplementary affidavit that we exchanged before this hearing in our heads demonstrate to your ladyship the financial position is dire. Without the PCF, it cannot continue operating. There was originally PCF, as your ladyship knows, made available for a limited period. It was then extended by the RDC. That's what we had, that addendum 11. And now we find ourselves with yet a further lifeline, as it were. This is not a party who's withdrawing an ill-fated application. It's not a party who has brought an application for a winding up that your ladyship should find that there's no merit in. On the contrary, it was necessary. And it would be necessary had we not received this agreement yesterday. It would have been necessary today to move your ladyship for a winding up. A learned friend also argues that the BRPs should have withdrawn this application before, at an earlier stage. Well, with respect, that ignores reality here.
Well, in April, that is.
Absolutely. That at once, all we got in April was a further lifeline for temporary PCF. That allowed us to continue till now, to June. That's why it was adjourned, and we are here. Up until last night, nothing had changed, and we would have been moving for a winding up. Only by virtue of the further PCF that's now made available are we able to avert a winding up now. And the prospects are considered to be reasonable that hopefully a rescue can now be achieved, if there weren't the party spoilers, as it were, who are seeking to do everything in their power, on the one hand arguing that there shouldn't be a winding up, but doing everything in their power to avoid a rescue for whatever agendas they may have. So this isn't a question, our learned friend says rather inappropriately, that the BRPs are seeking sympathy. This isn't ad misericordia plea to a ladyship. This is a reality where we're saying the reason why there's no need any longer under the Act to seek a termination and a winding up is because we now have this new agreement. That's the current position. And we submit for Abrina now to be coming and arguing that the company should pay their costs for their intervention and their participation in this, with respect, we submit entirely unfounded. So if one, I was about to say that if this debate has to go on much longer, the BRPs would be justified in seeking costs against Abrina for the time that we're taking over this issue. It really shouldn't be taking any time. As far as RGS is concerned, there's a difference, and I think it arose from something your ladyship raised. There's a difference in the cost of the counter application and the cost of the application to terminate business rescue and wind up. With respect, the counter application is a discrete issue, and that will no doubt wind its way through the legal process for however long that takes, in order to determine whether the business rescue plan should be set aside as an invalid plan. There's no need at this stage, where we know currently, because of the agreements reached and because of what will currently be made available, it would be inappropriate to keep the winding up application hanging there. So we've got to terminate that process, and that's why we're seeking the withdrawal of that application. Once we deal with that, there's no need to reserve costs of that application, because there's nothing that's going to change or be influenced by the...
to reserve costs insofar as RGS
Yes.
goes on the main application.
Yes, they want their costs to be reserved pending the determination of their counter application. They're entirely separate matters. And the one thing that RGS, as the Abrina, cannot and does not say to your ladyship is that, in fact, you have money, BRPs. You should never have brought a winding up application because you had money. RGS's, the high watermark of their argument is that BRPs, you shouldn't be implementing this plan with vision. What you should be doing is going in search, whatever this might be, this golden rainbow. You should be going in search of another plan, which, by the way, we will be there on many, many strings and ifs and buts. But we'll be there as an interested person to try and muscle ourselves in to a business rescue plan with us. They've not been able to show, and they wouldn't be able to show, that until and unless that happens, and that's really a space, if that, until and unless that happens, this operation cannot continue. The winding up would have been necessary, and the only thing that has prevented and saved the winding up is the RDC's funding. Obviously, we heard supported very heavily by the Minister. So for various public policy reasons, it's considered very important from the ministerial level through the RDC that this company be saved if at all possible. Jobs saved, the economy, but yet we now have RGS, and I use the word party spoiling, which with respect they are, for whatever strategic reason they may have in mind, trying to avoid on the one hand a winding up, but without any offer of funding. They're not coming to the party to say we will offer PCF, we will put in money, we will make sure that your financial position is in order.
Mr. Sybil, perhaps on that ground, you should reserve that argument for tomorrow's counter application.
No, one can.
Yes.
But I'm saying to your ladyship that as far as their costs are concerned, there's no need to delay the order in regard to cost of the main application. On the counter application, we can have that argument. Certainly.
Yes.
Thank you. As your ladyship pleases.
Maybe I just suggest one issue we've got, and issue of the interview, whether or not we're given.
Since I'm giving you a second bite at the cherry, it's subject to him replying.
Lady, just on the one issue
Yes.
that he's raised on the question of the intervention. Lady, my recollection of the matter was that when we served the application for leave to intervene, we were the first parties to enter the fray. The applicant's attorneys wrote to us and said to us to simply file our affidavits. It was never going to be an issue of us having leave to intervene. When the matter was informally before the judge president at that stage, it was agreed that some parties wouldn't file formal applications for interventions. In fact, I believe the Turks didn't file a formal application. Apart from that, I beg your pardon, Malan says that he did. I wasn't aware of it. I know they did a notice of motion. I haven't seen the affidavit.
You know, they had filed a formal
Lady, I haven't
application.
seen. I apologize.
Yes.
Lady, but the position is there's no order for interventions ever been granted in this matter. It appeared from the from our answering affidavit, Lady, there's a letter from them where they've agreed to us intervening in the matter. Apart from that, Lady, in our application for leave to intervene, we have annexed a copy of the cane supply agreement, which indicates that that agreement is in place until 2036. It requires us to deliver cane to Tongaat Hullett, no one else. Lady, the effect of that means, effectively, Lady, we are an affected party for all intents and purposes, Lady.
Yes.
Milady, there's one other aspect, and obviously Malanafin can respond to it. Milady, on the aspect of Malanafin indicated to Milady, and for some reason we always are associated with RGS, Milady, but in some instances we may be on par with, in respect of what they're saying. But we've always maintained, Milady, we'll see from our papers, that they have not made out a case for it. We haven't relied, Milady, on there being alternative plans. We have mentioned there may be alternative plans. We said in terms of the Act, they haven't demonstrated to this court that there's no reasonable prospects. And in that regard, Milady, that's why I mentioned what happened in April when we came to court. That facility was then provided to them. They never accessed that facility, but managed to run Tongaat Hullett until now. And that's on the papers from IDC. So there was no urgency in the matter being brought at that stage, Milady.
Yes.
Milady, those are my submissions.
Yes, thank you. Sybil, anything briefly in relation to what Mrs. Deodath has raised?
Point out, your ladyship is aware of the definition of affected person under section 128(1)(a). The BINA do not fall within the definition. Secondly, if I can just indicate something, and it's something that needs to be, with respect, ventilated. There seems to be talk of BRINA bringing its own application, similar to RGS, to set aside the plan. I think we should be told if that's intended. If that's so, then obviously it may influence how we deal with RGS's application, because we'd need to deal with it. But
I think that is something for the parties to decide on and discuss. It is not before this court. I know nothing about it.
well, I want to put on record, that's what we've been led to understand, but it's an important factor that should be disclosed if that's the intention.
Well, it is on record, and it is up to Mrs. Deodath and
Thank you.
those instructing her to decide.
Thank you.
Yes. Thank you. This morning, this court was to have heard an application for the winding up of Tongaat Hullett Limited. It was an application brought by the business rescue practitioners as applicants after they had formed the view that there was no reasonable prospect of Tongaat Hullett being rescued. The application, and it is common cause, was opposed by certain parties and affidavits were filed. A counter application was brought by the entity known as RGS. Until this morning, affidavits and heads of argument indicated that the matter was to be argued and that the BRPs were going to move for a provisional order of winding up. Late last night, I'm advised, and certainly this morning, an affidavit was filed by the BRPs wherein it was set out that there were continued and ongoing engagements between the parties, which resulted in heads of agreement and the conclusion of a further post-commencement finance amending agreement being concluded. The date of this agreement is 16 June 2026. Under those circumstances, the BRPs formed the view that there is now a reasonable prospect of Tongaat Hullett being rescued, and accordingly sought to withdraw the main application before this court for the winding up. Mr. Subel, who appeared with Mr. Shapiro in respect of costs, stated that each party ought to pay its own costs. Certainly, Mr. Fine, who appears for the IDC, Mr. Blau, who appears for the Vision parties, Mr. Van Rooyen, Mr. Allsworth, were in agreement with this. Mr. Kotze, who appears for RGS, was of the view that the costs in respect of the main application ought to be, in respect of RGS, ought to be reserved for when this court hears the counter application brought by RGS. Mrs. Deodath, whilst supporting the withdrawal of the winding up application, in other words, the main application, sought an order that for costs on behalf of Abrina, leaving the scale of costs in the discretion of the court. The basis for seeking costs is that Abrina is a small cane grower and was forced to come to court to lay its opposition to the winding up before the court. She further submitted that the applicants, in other words, the BRPs, had not acted properly in bringing the application, had not placed sufficient information before this court, for this court to have heard the liquidation application in the first place. And she further submitted that the BRPs ought to have withdrawn the application when this court heard the matter on the 16th of April. In reply, Mr. Subel stated that there was no, or submitted that there was no debate that Tongaat Hullett Limited is financially distressed and that the BRPs acted as they ought to within the ambit of the Companies Act, particularly Section 141(2), in bringing this application. It was further submitted that this particular application is an application sui generis and that the financial position of Tongaat Hullett was dire when the application was brought. So it is not a case of he submitted of a party withdrawing an ill-fated application. I am satisfied with the submissions made by Mr. Subel in this regard, and that each party ought to pay its own costs, and particularly that Abrina is not entitled to its costs. In relation to RGS's submissions, the withdrawal of the main application, in my view, must also come to an end. It would serve no purpose for the costs in relation to the main application to be reserved in respect of RGS. In the circumstances, I make the following order. The applicants are granted leave to withdraw the main application in respect of the winding up of Tongaat Hullett Limited. There will be no order as to costs. The counter application is adjourned for hearing to tomorrow morning, being 18 June 2026 at 9:30. That being the court's business, court will rise.